Hello everyone. Thanks for coming to our facility here today. It's good to see, as Chris and Derek both mentioned, a lot of new faces here today that haven't, I think, first timers at the iCFO conferences. So hopefully some of this presentation, I'm going to just talk for a few minutes about IP law and some basics, and then if you have any questions or want to talk about anything in more detail, I will be around today, or I'll have some cards over there that you can take, and feel free to give me a call. Knobbe Martens, we've been around for a long time. We just had our 50-year anniversary this last year, and we are specific to IP law. So we do patents, trademarks, copyrights, and litigation related to IP. We are the third largest IP firm in the nation, and that number there at 267 attorneys, that has gone up since this. That's actually about a year ago. We're at just right under 300 now. Offices mostly on the West Coast, but in the last couple of years we've opened an office in DC, so we have a presence there by the federal court, which is the appeal court that hears all patent appeal cases. So we represent clients from all sizes and all technologies. Here's just a list of some of the larger companies that we do represent. One thing that sets Knobbe Martens apart from a lot of other patent firms, I think, is our technical background. We have all of our attorneys have some sort of technical background. From my background is electrical engineering. We have chemists. We have a lot of PhDs in biology type sciences, physics. So any technology that you have, we have some expertise in that area. And I do a lot of software work. So a lot of people are, no matter what your business is, it seems like there's some hook into the software world or our online presence nowadays. So I help a lot of companies get patents, obtain patents on their software products. And with that, just a couple of things about, you probably heard about the American Invents Act. So this is some laws that were signed by President Obama in September 2011. And it had a lot of changes to various areas of patent law. And a lot of the changes have already gone into effect. The latest, the last batch of changes goes into effect March of 2013, so in just a couple of months. And one of the important changes that does go into effect is the U.S. is changing from a first to invent to a first to file country. So what that means is, in the past, if you were even if you weren't the first to file a patent application on a certain technology, if you filed on day one and a competitor filed on day 10, they could say, hey, I was actually the first to invent it, even though the other guy filed before me. Now that's going to change. For any patent application that's filed after March 15th of this year, it's the first to file the patent application that is presumed to be the inventor and have the rights to patent on that technology. So that's one important change that's going to be taking effect real soon. And so we're encouraging our clients to, and there's some other changes that will happen on that day too, with respect to what is prior art. In other words, what can the patent office use to reject your claims in your patent? And so we're encouraging people to file applications before the March 15th date, if possible. So just a couple of other things. Just one of the things that startups often are unaware of, I guess, and can impact them is, one of the ways they lose patent rights is by not filing for patent protection soon enough. And that's what this slide emphasizes. That is, in the US, you have 1 year from your first sale or offer for sale, publication, or public use to file a patent application on that technology. If you do not, then you've dedicated those rights to the public. So if you've had a trade show 8 months ago, 10 months ago, where you talked about your invention, your product, anything that you think might be novel and might be covered by patent, you want to start seriously thinking about investigating whether or not you should be filing a patent application, or you may lose rights to do that altogether. For outside the US, you don't even have that 1-year grace period. So in other words, you have to file something, a patent application, before there's any public use or disclosure. So here's just a kind of another way to say that the common ways that people lose their patent rights. You accidentally disclose product details before a patent application is filed. A lot of people don't recognize the invention. So we get a lot of people to come in and say, hey, we got this new business, this new product, but I don't think it's really patentable. We've been working on it for years, and we've come up with something we think's cool, but is it really new? And more often than not, there's things in there when someone from the outside looks at it where you can say, yes, there is some things here that are potentially protected by patents. So that's just a thing, you know, when you're in the day-to-day of the development and the engineers and the programmers, they don't oftentimes think that what they're doing they miss the big picture of what they've done. So sometimes it's good to talk to somebody else on the outside and just have them, kind of give their thoughts on what they think might be new there and protectable. Let's see. I don't want to spend too much time here, but again, the American Events Act, first amendment to file system, that's going into effect soon. There's some new procedures for third-party submissions of prior art, meaning that once you get a patent issued or your competitor gets a patent issued, there's some new procedures that have gone into effect now where you can challenge the validity, basically reopen examination of a patent. And that's all I had prepared. Are there any questions? And I'll be here all day, probably in the back if you want to talk, or afterwards.